everyone, and welcome to Daily Newspaper Analysis, which is brought to you by LawSikho. So, today we have one article for our discussion at length, which has been taken from the Indian Express. The title of this article is The Right to be Different. So, this again brings about the discussion about the Karnataka High Court's order about the hijab case, and that how we have this right to be different, and yet we can live together as a harmony and as a secular state at all. The next segment is about news updates, which will be important for our prelims exam. And finally, we'll be concluding with the legal news for the day. So the first one that we are discussing about, and the only article actually that we are discussing about today, is the right to be different. So the Karnataka High Court's order on the hijab issue puts to question the entire future of Indian judiciary based on the faith versus constitution controversy. So the Karnataka High Court has upheld the qualified public space doctrine in the hijab case in order to prevent a sense of separatedness. So here, actually, as a judgment has come, wherein the High Court of Karnataka has said that wearing hijab would not be accounted under essential practices for under Article 25, that is right to religion of the Indian Constitution. So basically, to avoid or to prevent any sense of separatedness, it has actually tried to bring about this doctrine of qualified public space. So basically, what it does, the identities are both ascribed and fluid. So like in the Shahabano case, it teaches us three human rights when it comes to the process of identification. Firstly is the right to have an identity. Second is the right to acquire different identities. And third, the right to manage the conflict of such identities. And now the Karnataka High Court has also missed answering the light of Article 51A, that is the duty to preserve the compositeness of culture, wherein it has actually, by giving this judgment that wearing hijab is not an essential practice when it comes to following Islam as a religion under Article 25, it definitely might have missed on observing and preserving the compositeness of the culture that India holds. Now, since the referral of matters to a bench of 9 judges, Supreme Court now has to review the Sabrimala decision, constitutionality of the Daudi Bora female genital mutilation case, entry of non-Parsi women into the fire temple, and of Muslim women into mosque, while answering the larger questions of ambit of religious freedom. So the Karnataka High Court was right in its intention of arresting propaganda for separation. However, the constitutional governance entails rectitude and responsibility in the exercise of power. And that is why in this regard, maybe a wider or a bit of broader ambit must have been, or it could have been even more appreciated. So further, the Puttaswamy case itself held that the choice of appearance, the way you want to appear, the way you want to dress up, and apparel, by wearing your clothes, are a right to one's privacy, and the same may not necessarily be based on religious beliefs falling under Article 25. So even if we do not take Article 25 for the consideration, even if we talk about Article 21, that is right to life, and under that we have right to privacy. So the way one wants to dress up, the way one wants to carry oneself, that is one's own private right, and that is one's own right to privacy. And that is why it need not be, in lines with the religion or as such, but here, no one should be hampered to at least exercise this right in the very first place. With this, let's discuss the news updates for the day. World Health Day, that is today, 7th April. So in the midst of a pandemic, a polluted planet, increasing diseases like cancer, asthma, heart disease, and World Health Day 2022, WHO will focus global attention on urgent actions needed to keep humans and the planet healthy and foster a movement to create societies focused on well-being. Second, Kashmir gets its first virtual e-museum. So a rare virtual museum from Sopore, which is an estimated 40 kilometers from Srinagar, will be showcasing the lifetime collection of female Kashmiri educationist Atika Banu. She collected a huge repository of artifacts from door to door, and after her passing away in 2017, she leaves behind a glimpse at the life of 17th and 18th century life of rural Kashmir. So the grounds of this virtual museum was cleared by Alif Foundation, an international organization involved in protecting cultural heritage. Third, veteran Bengali writer Amar Mitra wins O. Henry Award. So Amar Mitra wrote the story Gamburo in 1977 when he was only 26 years old. Today, it has earned the OG Foundation, founded in 1919. Henry Prize, whose past winners have included William Faulkner, Saul Bolo, and Raymond Carver. Fourth, second edition of Swarm drone content launched. So the Defense Minister Rajnath Singh launched the Meher Baba competition, the second part of it, the second edition of it, a contest in the growing indigenous drone industry aimed at developing technology for a swarm drone-based system to detect foreign objects on aircraft operating surfaces. Fifth, Burkina Faso ex-president found guilty. So Burkina Faso's former president, Blaise Compaoré, has received life sentence in absentia due to his role in the assassination of his charismatic predecessor, Thomas Sankara. Sankara remains a hero, often called Africa's Che Guevara for his anti-imperialist stance and austere lifestyle. Sixth, United Nations International Day of Sport, that was yesterday, that is for 6th April. So the International Day of Sport for Development and Peace, which takes place annually on 6th April, presents an opportunity to recognize the positive role sport and physical activities play in communities and in people's life across the globe. Let's see what do we have for legal news today. First, forcible dispossession of private property of a person without following due process of law. So an appeal against Himachal Pradesh High Court judgment which disposed a writ petition challenging dispossession and seeking compensation allowed in the absence of written consent to voluntarily give up their land, the appellants were entitled to compensation in terms of law. State directed to treat the subject's lands as a deemed acquisition and appropriately disburse compensation to the appellants. The case name is Sukhdat Ratra versus State of Himachal Pradesh. Second, dissolution of marriage by mutual consent permissible under Muslim personal law, says Bombay High Court. So, observing that a family court can dissolve the marriage of a Muslim couple by mutual consent under the Muslim personal law, the Bombay High Court quashed criminal proceeding against the husband based on the couple's amicable settlement in the family court petition. So, this is all for the day. We hope you liked the session. Thank you so much for staying tuned with LawSikho.